Good day, viewers. The way Bola Tinubu and the federal government of Nigeria is taking the Niger crisis so serious, it makes me think whether they want us to forget about the court proceedings because of Niger crisis. Now, I have beginning to think that these people are taking this Niger Coup situation so serious because they want to distract the court proceedings. This could be a political strategy that let us take this thing serious so that these people will forget about the court proceedings to enable us to do what we want to do. However, it is trending in French-speaking African countries that Tinubu was caught in the US on narcotic trafficking and drug-related case that he forfeited $460,000 to the Bank of America. Now, this situation is what I want us to talk about. How they deliberated it in the court and what is the outcome? Are we expecting that the judges are going to disqualify Tinubu on this ground? Believe me, this is trending today. So listen to what transpired during the court process about this case of narcotic trafficking and drug-related case.
During their defense, Bola Tinubu, through his legal representatives, asserted that Tinubu's $460,000 forfeiture judgment was not registered in Nigeria and therefore can't be relied upon by the Nigerian court. However, Peter Obi and the Labour Party punctured this claim again in their final address by telling the court that the judgment is documented evidence that was issued, certified, sealed, notarized, and validated by the United States court. The petitioners supported their case by citing a ruling made by the Supreme Court in the case of Obi Lagos vs Ocean Steamship Nigeria Limited, which occurred in 2004. Part of that judgment by the Supreme Court reads thus: a party who intends to rely on the judgment of a foreign court must comply with either of two options, namely A, by sealing the judgment with the seal of the foreign court, or B, by a copy certified by the legal keeper with a certificate or of a notary public or of a consul or diplomatic agent stating that the copy is duly certified by the officer. Peter Obi's lawyers asked the court to sustain that the judgment against Tinubu, which they offered as proof, satisfied all these requirements. They also refuted Tinubu's assertion that the judgment needed to be registered in Nigeria. During the defense session, Tinubu's lawyers cited Section 3 of the Reciprocal Enforcement of Foreign Judgment Ordinance, but in their final address, Labour Party and Peter told the court that the act cited by Tinubu's legal representatives does not apply in this case because Peter Obi and the Labour Party are not seeking to recover any money payable under a foreign judgment or enforce any money judgment against Tinubu. Bola Tinubu, through his legal representatives, also cited Article 54, subsection 1C of the United Nations Convention Against Corruption, which talks about member states providing mutual legal assistance concerning property acquired or involved in the commission of an offense established in accordance with the convention. Peter Obi and the Labour Party told the court that Tinubu's judgment they tendered in evidence has nothing to do with the mutual assistance, and therefore Tinubu totally missed the point by citing Article 54, subsection 1C of the United Nations Convention Against Corruption, which talks about member states giving reciprocal legal aid with regard to property acquired or used in the commission of an offense defined by the convention. Therefore, Peter Obi's petition is unrelated to the United Nations article Tinubu referenced. Labour Party asked the court a crucial question, which is whether the civil forfeiture as ruled by the American court in Chicago is comparable to a fine as defined in Section 137, subsection 1B of the 1999 Constitution of the Federal Republic of Nigeria. Of course, the response is in the affirmative. Labour Party backed up this address with a Supreme Court judgment that was delivered in 1993 in the case of Austin versus USA. The honorable justices in that unanimous ruling by the US Supreme Court held that forfeiture is a fine and a punishment regardless of whether it results from a criminal conviction. The court further ruled that the phrase forfeit was used for fine by the US Congress. They continued by listing numerous definitions of forfeit, which obviously implies implies fine. The legal representatives of Peter Obi and the Labour Party did not end there. They cited Teams versus Indiana 2019, another ruling by the US Supreme Court. In that instance, Teams was the target of civil forfeiture actions brought by the state of Indiana. They asserted that his Land Rover SUV was used to transport drugs, but this was naturally disputed and appealed up to the Supreme Court. But in a unanimous ruling, the Supreme Court concluded that the state may use fines in accord with criminal objectives of retribution and deterrence. This is because other forms of punishment cost the state money, but fines are a source of revenue to the state. You might have noticed that all of the legal precedents mentioned by the Labour Party and Mr. Peter Obi's legal team consistently define forfeiture as a fine or a punitive economic consequence against the people or person whose property is affected. Teams contested the forfeiture of his SUV in one of the cases described. However, Tinubu did not contest the forfeiture of $460,000 in drug proceeds. What does that suggest to you? What does that tell you? Let me know your thoughts in the comment section. That somebody was fined $460,000 and he didn't bother to appeal the case. Rather, he ran away from the United States. The legal team for Peter Obi also cited the 2015 Administration of Criminal Justice Act, which defines fine as any pecuniary forfeiture or pecuniary compensation payable under this act. Penalty includes any pecuniary fine, cost, forfeiture, or compensation recoverable under an order. In their closing defense in court, Tinubu's lawyers based all their arguments and defense on the fact that Bola Tinubu was never convicted by the US court, that rather Tinubu just forfeited money. Forfeited money for what, if I may ask? I've never heard of anyone who forfeited $460,000 he or she legitimately worked for. If I were the judge, I would be interested in finding out why Bola Tinubu forfeited $460,000 to the US in 1993, not in 2023. We're talking about forfeiting $460,000 as far back as 1993. How did he get that sum of money? If you have an idea, please talk to me. Let me know your thoughts in the comment section. How did he get the money that he easily forfeited and ran back to Nigeria? What was his business or businesses in 1993? And how much was he making per annum? The judges should know better than I do. In response to Bola Tinubu's argument that he was never convicted by a court in US, the Labour Party and Peter Obi urged the court to take note that the portion of the Constitution on which their petition is based is Section 137, subsection 1D, which disqualifies a candidate if he has been fined by a court and not if he has been convicted. Please take note of that. And you can see that in all the cases Peter Obi and Labour Party highlighted, a fine remains a fine, whether it is civil or criminal. Additionally, a fine is only imposed in cases of fraud or dishonesty, which are dealt with in the same session. The legal team for Peter Obi and the Labour Party also cited a ruling in Nigeria's Supreme Court that defined forfeiture as a fine. The Supreme Court ruled in the first judgment, Attorney General Ben Del State versus Abofodo, 1999, that forfeiture is the act of forfeiting something or of being forfeited. It is a penalty, a forfeit. It is synonymous with a fine, penalty, damage, confiscation. It is worthy of note that the incumbent Nigerian Chief Justice was one of the judges that delivered the judgment in Muhammad Abacha versus the Federal Republic of Nigeria 2014. According to the highest court in the land, these definitions make it clear that forfeiture is a punishment or fine imposed by the court. It has a criminal and punitive element. The two Supreme Courts in Nigeria and the United States of America thus define forfeiture as a fine following all these citations. So there is no doubt about it. Sequel to this, the Labour Party and Mr. Peter Obi stated that Section 137, subsection 1D of the 1999 Constitution of the Federal Republic of Nigeria has the following meaning and intent. A person who has forfeited property due to illegal activity, even though not convicted, should not be permitted to run for or hold the high office of President of Nigeria. In order to reinforce this claim, they said that the reason all is used twice is to separate persons convicted from persons who, even though not sentenced, are affected by an order of a fine imposed by a court. Therefore, this particular provision targets those who received court fines, like Tinubu in this instance. And even if they are not found guilty, they still violate the law. Even if they are not convicted, they still fall foul of the law. Labour Party told the court that any court was used in this particular segment. Therefore, the phrase any court includes the United States District Court for the Northern District of Illinois that issued the fine judgment against Tinubu. Although the Labour Party's legal team contended that any court refers to both local and foreign courts, Tinubu's legal team may contend that the drafters of the Nigerian Constitution intended to refer to the Nigerian court only. Certainly, I will expect them to go that route. The U.S. Customs Service disclosed that Tinubu had opened a bank account at the same address as a drop-off location for parcels from Nigeria containing narcotics. Therefore, even if Tinubu was not convicted, his actions border on money laundering and drug trafficking, all of which are classified as dishonesty and fraud. Contrary to what Bola Tinubu stated, the Labour Party maintained that the witness Tinubu summoned recognized that the judgment was not for money, which means that Nigeria does not require the judgment to be registered, as they claimed in their letter defense. Moreover, the witness's assertion that he holds a license to practice federal law across the United States of America is false. In addition, his assertion that the court relied on American Law Section 981, which addresses civil forfeiture, is embarrassing and contradicts his earlier claim that he is familiar with American law. As a result, Peter Obi and the Labour Party requested the court to rule that Tinubu was ineligible to run for president, as should be disqualified based on all of the above. Now let's look at Peter Obi's final address on the double nomination of Kashim Shettima, Tinubu's running mate. Peter Obi told the court that Kashim Shettima was the contender for the Borno Central Senatorial District before Bola Tinubu picked him as his running mate. Peter Obi and Labour Party's petition was based on Section 35 of the Electoral Act 2022, which provides that where a candidate knowingly allows himself to be nominated by more than one political party or in more than one constituency, his nomination shall be void. In the words of Peter Obi and Labour Party, we contend that the third respondent was ineligible to run in the February 2023 presidential election as the second respondent's vice presidential candidate, which rendered the second respondent's eligibility for the election null and void. Peter Obi and Labour Party also contended that every presidential candidate is required by the 1999 Constitution of the Federal Republic of Nigeria as amended to select a legitimate vice presidential candidate. Section 142 stipulates the following. Number 1. In any election to which the foregoing provisions of this part of this chapter relate, a candidate for an election to the office of the president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running for the office of the president, who is to occupy the office of the vice president, and that candidate shall be deemed to have been duly elected to the office of the vice president of the candidate for an election to the office of president who nominated him, as such associate is duly elected as president in accordance with the provisions aforesaid. Number 2, the provisions of this part of this chapter relating to qualification for election, tenure of office, disqualification, declaration of assets and liabilities, and oaths of president shall apply in relation to the office of vice president, as if references to president were references to vice president. So the unchallenged facts before the court are that the second respondent in purported compliance this constitutional requirement nominated the third respondent as his vice presidential candidate. He made the nomination on July 14, 2022, while the third respondent, which is Kashim Shettima, was still the senatorial candidate of the fourth respondent for Borno Senatorial District. This action clearly contravened the Constitution of the Federal Republic of Nigeria 1999 as amended and the extant provisions of the Electoral Act 2022, its manuals, guidelines, and regulations. Shettima was nominated as the vice presidential candidate on July 14, 2022, while he was still a senatorial candidate for the Borno Central Senatorial District. The Labour Party and Peter Obi stated this in their closing address. Now, in accordance with the terms of Section 142 of the 1999 Constitution as amended, Peter Obi claimed that the invalid nomination of Kashim Shettima as the vice presidential candidate rendered Bola Tinubu's nomination and election election as the presidential candidate invalid. In summary, Peter Obi's final address canvassed the following issues. Number one, the 2 nominations for Kashim Shettima. Number 2, forfeiture of $460,000 by Bola Tinubu to the US government. Number 3, real-time election results transmission from polling units to the IREF portal. Number 4, Tinubu not winning 25% of votes cast in Abuja. Number 5, inconsistencies in the margin of declared results compared to the evidence from forms EC8A. Number 6, errors in the IREF portal results. Number 7, changing election results and outcomes. Number 8, Benue State and Rivers were won by Peter. Number 9, arguments against classifying the FCT as a state. And number 10, Kenyan elections in 2017. In conclusion, Peter Obi and the Labour Party cited the 2017 Supreme Court decision in Raila Odinga and Ano versus Independent Electoral and Boundaries Commission and others in support of their argument. In that case, Kenya's top court removed Uhuru Kenyatta and warned the tribunal judges that failing to consider the evidence before them would be a breach of their obligations. The ruling reads in part, to dishonestly exercise that delegated power and to close our eyes to constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular the invitation may seem. Therefore, however burdensome, let the majesty of the Constitution reverberate across the length and breadth of our motherland. Let it bubble from our rivers and oceans. Let it boomerang from our hills and mountains. Let it serenade our households from the trees. Let it sprout from our institutions of learning. Let it toll from our sanctums of prayers. And to those who bear the responsibility of leadership, let it be a constant irritant. Now, the big question is, will the 5-man panel of justices of the Appeal Court Nigeria, who are in charge of this case, be courageous enough to serve justice like their Kenyan learned colleagues, or will they forfeit their reputation for dollar notes? Time will tell.
Ladies and gentlemen,